Hey, it's Christine again. Christine Faulkner, Sacramento and Elk Grove's Living Trust and Estate Lawyer with Cava and Faulkner. Thank you for tuning in to another edition of On the Daily with Christine, or The Daily with Christine. And this is a continuation of our series on Prop 19. So here's what we're going to talk about today, and here is why you want to stay tuned until the end of the video. We're going to talk about the parent-child and grandparent-grandchildren exclusion and the effective date of that portion of Prop 19 and how it works with an example. So it's important for you to listen all the way to the end. That way you can get a better picture of how this works from a property tax perspective, whether you can make a transfer to your children or grandchildren, when and how this can impact the tax base from an estate planning perspective, which is when you're looking at a property tax assessment. A transfer happens usually on sale or on death, and this is why this comes into play when we're talking about estate planning. Parents want to, or grandparents want to, leave their property to their kids or grandkids, and it's important to understand the tax ramifications from a property tax assessment perspective given Prop 19. So beginning on or after February 16th, 2021, the California Constitution has now been amended by Prop 19 to define the terms purchase and or change of ownership, which means they do not include a purchase or transfer of a family home in the case of a transfer between parents and their children if the property continues to be the family home of the transferee. We'll talk about what happens if the value of the family home exceeds the specified value test. So the family home means the principal place of residence, and this is only for eligible homeowners, and those are people who are disabled veterans or those 55 years old or older, meaning the transferor. And the home to be reassessed potentially is going to be excluded from reassessment if the property continues to be the family home of the transferee. So the transferor is the person who is essentially gifting the property. The transferee is the person who receives the property. So what does that mean from a practical perspective? To avoid reassessment, it means that the transferee, in this case, the child or the grandchild, actually has to live in that property. So if you receive a property because your parent passed away, but it's not going to be your primary residence, Prop 19 is not going to apply, and it will be reassessed at the current value, the current fair market value, if the transferee, the child or the grandchild, is not actually living in the property. So you might remember that Prop 58 is something that has been in effect since 1986. And Prop 58 essentially excluded transfers of real property between parents and kids from reassessment or from grandparents and grandchildren, assuming the grandparent's child had predeceased the grandchild. So that is something that's important to understand. A grandparent-grandchild exclusion only applies when the parent of the grandchild has predeceased the grandparents. But in those cases, transfers between parent-child, grandparent-grandchild were excluded from reassessment. That is no longer the case if the transferee, the child or grandchild, is not going to be living in the property. So something to be aware of from a tax perspective. So I will tell you that for me personally, my mom passed away in 2013, and my sister and I now co-own that property as a rental. Fortunately for us, we had that exclusion apply because that happened back in 2013 when Prop 58 was in effect. But because we are not living there, the new exclusions would not apply to us if that transfer occurred after February 16th of 2021, because we are using that as a rental property. So here's something else to understand. Even if you are the child and you happen to be living there and you now have had this property transferred to you after the death of a parent and you continue living in the property, you need to be aware of the value and how that impacts reassessment and how that's going to impact your new property tax value. So basically, if fair market value of the home is less than the sum of the factored base year value plus $1 million, then the factored base year value doesn't need to be adjusted. If it's more than that, however, there will be an adjustment. So let's talk about an example. So you have a single family residence and a factored base year tax value of $425,000. The parent dies on March 1st, 2021, and the property is inherited by the parent's only child. The residence was the principal place of residence of both the parent and the child. On the parent's date of death, the property has a fair market value of $1.75 million, so $1,750,000. So in that example, we're going to take the factored base year value, which is $425,000, and we're going to add $1 million to that. We're going to determine if the assessed value exceeds the sum of the base year plus the $1 million. So the assessed value of the property, basically fair market, was $1,750,000. So that is definitely worth more than $1,425,000. So what we're going to do is we're going to take the difference between $1,750,000 and $1,425,000, and the difference is the difference is about $325,000. We're going to add the $325,000 to the base assessment of $425,000 and come up with the new assessed value of $750,000. So I can tell you that that is a much better deal than having an assessed value be based upon the fair market value of $1.75 million. So remember that this applies only to transfers that take place after February or on or after February 16th, 2021. Something else to be aware of: every other year beginning February 16th, 2023, and every other year thereafter, the $1 million is going to be adjusted by a percentage change in the house price index for California. So basically a cost of living increase. So a lot to think about here when it comes to property tax assessment for what generally we're talking about, which is inherited property. And if you are concerned at all about transferring property to your kids and avoiding any kind of reassessment, obviously you don't have to wait until death. Property 58 applies to both a purchase or transfer that can be during lifetime. You need to make sure that you do that prior to February 16th, 2021, or Prop 58 will no longer apply. You will have a much more conservative approach when it comes to transfers. You'll have a higher litmus test, meaning you can't just transfer a property to your children and avoid reassessment for property tax purposes unless it is their primary residence. Your children or grandchildren will have to be living there with you. So that is a big deal. You can't transfer what will amount to be an income producing property and avoid reassessment after February 16th, 2021. So a lot to think about. If you've been thinking about making a transfer during your lifetime, now is the time to really deeply consider these circumstances and how they apply to you, and whether this will be a concern if you wait until after February 16th, 2021. So more on this subject. Thank you for tuning in. I hope you find this information valuable as to Prop 19 and how it may apply to you and your family. And like our videos if you like the content, subscribe to our channel, and let us know what other content you would like to hear from us, and we'll be happy to produce it. Take care and see you next time. Bye-bye.